Good afternoon and welcome to CUA Law. For most of you, this is welcome back. It's really wonderful to see a lot of familiar faces here at the law school. And for those of you who have never been here before, it's wonderful to have you here this afternoon. My name is Megan LaBelle, and I'm a professor here at CUA Law. And along with my colleague, Elizabeth Winston, I serve as the co-director of the Law and Technology Institute. So while LTI is technically a new institute here at the law school, it has a long history. As most of you in this room probably know, LTI, or the Law and Technology Institute, was formerly known as the Communications Law Institute, or CLI. And CLI was a leader in the field of communications law for over 3 decades. About a year and a half ago, a decision was made to expand the scope of CLI to include intellectual property law and information privacy law, the idea being that all of these fields have technology in common. So one of the things that CLI did so well was to offer wonderful programming to our students and alumni and the community, and we're very excited this afternoon to be continuing that tradition. So before we get started, I just wanted to express gratitude first to Dean Attridge for his support of LTI and the programs that we put on each year. Second to Constantia Dedulis, who is outside and has welcomed everyone and has made all of this possible. And then, of course, to our LTI Alumni Association, formerly known as the CLI Alumni Association, which is co-hosting the event. And in particular, I would like to thank and introduce Patrick Halley. Patrick is of counsel at Wilkinson, Barker, and Knauer. He is a graduate of our law school, and he is currently the president of the LTI Alumni Association and does so much to help us with this event and many others. And before joining his law firm, Patrick spent several years at the FCC in different capacities, and so he's a wonderful person to be moderating our panel today. So thank you, Patrick, and I'm going to now turn it over to him. Welcome.
Thank you very much, and thank you everybody for coming. It's going to be a great discussion. We're delighted to have Commissioner O'Reilly and a great group of folks who are certainly expert in their field for the topic that we're going to be discussing today. So it's my pleasure to introduce Commissioner O'Reilly. I did have the pleasure of serving at the FCC for a little under 5 years and was there when Commissioner O'Reilly arrived. And it was always a pleasure to work with the commissioner, even if we couldn't convince him that what we were doing was a good idea, which happened on occasion. So Commissioner O'Reilly was nominated for a seat at the FCC by President Obama on August 1st, 2013, and was confirmed unanimously by the Senate on October 29th, 2013. More recently, in January of this year, he was sworn in for a new term following his renomination and confirmation by the Senate. Prior to joining the FCC, Commissioner O'Reilly had a very long and successful career on the Hill. He was the policy advisor in the office of the Senate Republican Whip, led by Senator John Cornyn. Prior to that, he was an advisor and deputy chief of staff for Senator John Kyle. He previously worked for the Republican Policy Committee in the United States Senate as a policy analyst for banking, technology, transportation, trade, and commerce issues. So a lot of different issues there from 2009 to 2010. And prior to that, he was in the office of Senator John Sununu. I don't know if the commissioner remembers, but when my previous career working for the National 911 Association, we had some very lively discussions about what the regulatory requirements should be for voice over IP providers. It was a fun discussion.
I think we disagreed at that point too.
I think we did disagree at that point too. That's okay. And before that, he was on professional staff for the Committee on Energy and Commerce from 1998 to 2003, and was a policy analyst from 95 to 1998, and he got his career started in 1994, 2 years before the momentous Telecommunications Act of 1996, working for Congressman Tom Bliley. So the commissioner's had a very long career both at the Hill, on the Hill, which is the overseer of the federal communications where he is now. So he has unique insight into both the legislative process and the regulatory process, and I think we will all gain from his insights. So it's my pleasure to introduce Commissioner Rosenthal.
Well, thank you. In hearing that introduction, which I've listened to a couple times in my career, I realized that actually Friday is my anniversary. 3 years at the commission on Friday. So 20 years in Congress and 3 years at the commission. It's maybe a little too much government, huh? But I have some prepared remarks, and then I promised Patrick I would take any questions that anyone had, and then get to the distinguished panel as well. So I want to thank Patrick for a very kind introduction and for including me here today. I appreciate the opportunity to be the kickoff speaker for this panel on an important topic just considered by the Federal Communications Commission. As many of you might better refer to it as the Catholic Law School Annex. Not surprising, many of the graduates of this institution play key roles at the commission and are integrally involved in the formation of communication policy. They're in the know, pulling the levers of policy and influencing the outcomes of our decisions. As a commissioner in the minority, however, often left out of the loop, it makes me a little bit jealous, I must admit. But turning to the topic at hand, as many of you know, the commission recently adopted rules to impose new burdens on supposed rogue internet service providers under the guise of protecting consumer privacy. The vote fell 3-2, and I was again in the dissenting camp, as so happens. And the text of the item is not available as of yet. We were just asked that question earlier, how soon? It should be available soon, and it's a flaw in our procedures that you don't already have it in your hands, in my opinion. But I'm free to express my thoughts and views on the item itself, and then on the topic as a whole. So let me set the stage for our discussion by highlighting the true purposes of data collection and analytics in this sphere. For those that have examined this issue as I believe I have, you come to realize that there are really only 3 broad reasons why commercial companies collect and use consumer data, either online or offline. The first is to market additional or new products or services to their customers, or to sell information to others to do the same. From internet banner ads, to store mailings, to grocery store coupons and the like, the ultimate goal is to reach the customer to make a sale. The more data collected, the greater the chance to target the pertinent material or merchandise to the right people, minimizing the failure costs for the company and the annoyance factor for uninterested consumers. The second function is to improve the functionality, profit efficiency, and other aspects of the company's operations. By analyzing the requisite data sets, companies can detect how to improve their offerings or the means they use to offer products and services. In other words, it's a chance to examine the point or points at which companies' offerings can better meet the demand of consumers in the future, or, should where it be, show where their problems do exist. In addition, companies collecting data may sell such information to other companies for the same purpose. The last reason for private companies to collect such consumer data is either to comply with legal or law enforcement requirements or to sell information to government entities. Sometimes this is done begrudgingly, and other times it results in business opportunities. Even for the most privacy-conscious person, the first 2 purposes should not produce the same level of concern as the last. Admittedly, there may be an added nuance factor of receiving additional tailored ads from companies seeking to more effectively target them for sales. On the other hand, better targeted ads and more proficient companies can serve to meet more consumer needs. While such advertising may help increase demand for those trying to sell specific goods and services featured in ad materials, it also dramatically reduces the cost of products and services for consumers. For instance, Just imagine the cost of local television broadcasting or Google's applications without advertising. Far from being a dirty word, it is an honorable profession harnessing some of our nation's most creative people and is a key ingredient in American commerce. More importantly, we should all acknowledge that legitimate advertising is a societal good that is also protected by the U.S. Constitution. Those seeking to squash it, attack it, or restrict it had best do more homework before making outrageous statements or seeking to undermine it. You'll get little support doing so from me. On the other hand, I would argue that the American people should be most concerned about how data is collected, compiled, analyzed, and shared with national security or law enforcement entities. In the wrong hands or used for the wrong purposes, such data could ultimately be used to lessen individual liberty and or private property rights. Combined with mechanisms to force compliance, the use of data could be abused or manipulated in a harmful way. But that gets far afield from the FCC authority, and I have to defer to Congress on whether or not to impose limitations on sharing such information with government representatives. Setting aside the law enforcement debate, however, I think it's important to understand my charge as a commissioner. My first function is to determine whether or not there is a problem that needs to be solved or resolved. When determining whether to dictate government interference in the private marketplace, you better be sure that there is data-driven evidence of market failure and not just hypothetical or potential harm. New FCC regulations impose burdens on providers that affect their decision-making in terms of products or services offered, markets entered or withdrawn, people employed or to be let go, consumers to be served or abandoned, and many other factors. It can dramatically change the direction of the market. Assuming a problem or issue exists, I next turn to whether, and if so, to what extent, the Commission has authority to take some action. To provide guidance and boundaries, Congress governs our activities via the Communications Act of 1934, a couple of lesser statutes, and close oversight. To be clear, there may be areas where I may agree action is warranted, but it is in fact not permitted by law. My role is not to charge ahead based on my personal interests and beliefs. Instead, I have the right, and in some cases the obligation, to inform Congress of my views in a suitable way, and then let our elected officials make decisions as they see fit. With that understanding, let's return to the recent FCC item, which is focused solely on limiting the ability of one set of internet companies, broadband providers, to collect and use consumer data to the extent that they actually collect and or use it. How the Commission arrived at last week's action was fairly predictable. By reclassifying broadband internet access service as a communication service under Title II, part of the misguided campaign to oppose net neutrality rules, the FCC usurped part of the FTC, the Federal Trade Commission's, role in overseeing broadband privacy. Not content to inherit a system that, by almost all accounts, was working quite well to protect consumers, the FCC dismissed the privacy structure developed and implemented through extensive precedent by the FTC over a number of years. In its place, the Commission explored radical alternatives, finally settling on an item that establishes new and unique restrictions on the collection of and use of information by most internet service providers. From my perspective, the biggest substantive areas of concern are the ill-conceived definition of sensitive information, which includes web browsing history and application usage, and thus requires consumer opt-in mechanisms, the unreasonable limitations on first-party marketing, and the effective establishment of a new Commission regime to review consumer privacy trades. Let me walk you through my objections to the Commission's inappropriate action. 1, no existing problem. Fundamentally, I disagree with the notion that there is an existing problem worthy of Commission action. There is very little real evidence in the record that ISPs have or are planning to dissect the consumer traffic that they carry to a degree that would result in consumer harm. To the contrary, the record shows that a substantial percentage of internet traffic is encrypted, with that number only to increase in the very near term. That means that ISPs, certainly the smaller and medium ones, but likely the larger ones too, have little to no direct access to the wealth of consumer data and information considered valuable. At the same time, consumers use multiple platforms to access the internet, significantly undermining the Commission's claims that broadband providers have unique or unparalleled access to consumers and their information. Even if you ignore these facts to support the need for new rules, the prudent thing would have been to adopt the FTC approach, not to illogically capture web browsing history or app usage that by their very nature are not intrinsically important, much less private. As with the FTC's model, if the use of the web or an application generates sensitive data, such as health or financial information, then it is already covered by other existing categories. There is no need to be over-inclusive in the definition scope. Number 2, no legal authority. The Commission's attempt to fit broadband in the current law, specifically Section 222 of the Communications Act, is fundamentally flawed. The plain language of the statute speaks in terms of telephone service, and no other section is remotely relevant to authorize FCC action. Accordingly, it is in its efforts to shoehorn broadband into this regime, the Commission is forced to ignore or explain away language that clearly contradicts its position, regulate by analogy, or simply create new obligations out of thin air. And in doing so, it did a poor job. Number 3, undermines consumer expectations and creates confusion. The FCC, my fellow colleagues, claim that in moving to sensitivity-based framework, the rules will be more properly calibrated to customer and business expectations. But requiring opt-in notices for web browsing history, application usage, is a significant departure from the FTC approach, which is the basis for the current consumer and business expectations. Well, this has been in effect. Businesses have been able to provide great value to customers in the form of discounts, convenient features, and other new and innovative services. Requiring opt-in consent for these categories will destroy that value and upend years of settled expectations, burdening rather than benefiting most users. Additionally, consumers will receive new privacy notices from their broadband providers asking them to opt in for certain practices. If they do not opt in, but continue to see advertisements based on their web browsing and application usage, some will ultimately assume that their broadband providers are violating their privacy policies, when in fact, the ads originate from third parties not subject to the FCC rules. Number 4, enacts harmful restrictions. The Commission's action limits inferred consent to only first-party marketing within a service category, as well as marketing of consumer equipment and communication services commonly bundled together within the subscriber's telecommunications service. Here again, there is no rational reason to place undue restrictions on broadband providers. Instead, we should have extended inferred consent to the marketing of products and services offered by providers and affiliates, as long as the affiliated relationship is clear to consumers. As the record demonstrated, consumers expect to receive information from providers about new products, services, and discounts. In addition, if broadband providers cannot market new products and services on the same terms as online companies or even other brick and mortar businesses, there will be less incentive to invest and develop new services. In addition, the Commission installed a case-by-case approach to review and possibly reject privacy trades, which are the willing exchange of private information by consumers to providers for the service features and functions they offer. These type of consumer financial incentives are offered every day in the real world, and now ISPs will need to obtain a blessing from an agency that has no privacy experience or expertise. The end result is that broadband providers will be reluctant to extend and may even forego valuable offers and discounts that consumers would want for fear that they will fall into another zero rating style abyss. 5. Ineffective and costly. The ultimate absurdity of these new rules is that broadband providers remain free to purchase and use the information they need from other internet companies, including edge providers, because these other companies are not covered by the same rules, and they will continue to operate under the FTC's opt-out regime. Therefore, all the FCC has done is raise the transaction cost, requiring consumers to pay more for heightened privacy rules that they never asked for. So, hopefully I provided a sufficient platform and enough material for the subsequent panel to debate these issues in great detail. Before that occurs, however, I did promise that I would take some questions. So I want to thank you for your attentiveness. I don't see anybody sleeping. It's good. It's good. And I'll open the floor to whoever has the first question.
Just real quick,
Start with Patrick.
while you were speaking, because they must have been concerned about what you were going to say, the order was released.
Oh, there you go.
Let's write it together.
Okay, we'll be ready to address it in 5 minutes. Come back tomorrow.
Well, good luck to your reading. Had some fun times with that one. I have read it a couple times. A couple different versions, I must admit. As Patrick can attest, it's not unusual to send extensive rewrites over the process day. Yes, sir.
Brian Morrison with 3L here. Thank you, first off, for coming to speak with us. My question with U.S. Telecom being upheld by the D.C. Circuit and common carriers kind of being out of the reach of FTC authority, how do you see the commission? The commission had that obligation for data security then, as somewhat besides the 222. Did you want the FCC to go with that FTC approach then, if they were to do anything?
Sure. A couple of things. One, I have called that decision rather squirrely. That's a technical legal term. I'm sure that no, it is I found the Ninth Circuit decision to be not in line with the expectations for 20 some odd years of working at Capitol Hill in terms of, and I spent a great deal of time overseeing the FTC as well. So I find that decision just out of bounds. And we're going to have to see what happens in the en banc petition, and perhaps I suspect we're going to get to the Supreme Court on that case. So I think that's actually out of bounds, and it's not surprising the Ninth Circuit. They have quite a high rate of being overturned by the Supreme Court. I think the second highest that I can remember. So in and of itself, the decision doesn't make much sense to me. But I don't think that actually facilitates the need for the commission to act for numerous reasons. I've kind of outlined some of them. But to your last point, and that is, if the commission was going to act in this space, I wanted it to be consistent with what the FTC has already done and something that actually already works. Instead, what we've got is kind of a hybrid approach. We took half of their definition and then we added these two new categories to it and some other burdens as well. In doing so, we've created this bifurcated system where broadband providers can now have to live under one rules, and all of the edge providers, your Googles, your Facebooks, and all online companies that that we all love and that I use on a daily basis, live under a different set of rules. They actually are the ones that, and God bless them in some instances, they are the ones that actually have more access to your consumer data than your broadband provider does today. So I disagree with having a bifurcated approach. The argument was presented to me last week is like, well, okay, now that we are where we are, then the solution should be, for lack of a better word, just stick it to the edge providers. That is actually more troubling than you can imagine, because that is one of the biggest revenue sources that is funding the rest of the internet activity today. If you look at where Google's making its money, it's off of search. And off of search is coming because of the advertising dollars they're able to generate for multiple purposes themselves, and also the data that they sell to others for more advertising that I kind of alluded to. If you take away that piece, their biggest piece, think of all the other applications that they fund with that revenue today and what happens to that company. So I would say we have to be extremely cautious about having the approach we've done. I would do the opposite. I would say, look, let's reconsider what the commission just did, bring it in line with what the FTC did. Even though I probably wouldn't have liked to have been in that place, I was willing to consider such an approach. I just didn't win the day.
Come on. I have one. So you were on the Hill for 20 years and been at the FCC for 3. Different types of advocacy I'm sure you've seen in both roles. Different rules for how you can advocate depending on where you stood. Any advice for future practitioners here as to how to effectively advocate?
Sure. I'll give you a little bit. It's a great question, actually, because people always said that I was unlobbyable.
No.
I-
Good TV man, right here. This is.
I'll give you 2 pieces of advice. For what it's worth.
Tough.
I will say, know the issue that you're coming to lobby about inside and out. No, be the one that's the most knowledgeable on the subject, because you don't know what question some young kid may ask, some senator may ask, some chairman may ask, and you want to be extremely prepared. More than likely, the average person on Capitol Hill is going to be fine with the one-pager you leave behind. But I was that person saying, I want to see your FCC filing, I want to see your FTC filing, and I want to ask you a bunch of questions about it. So be prepared. And 2 is know your audience. You have to know who that person is. I'm going to be the one that's going to ask the tough questions, and you want to be prepared. But that other guy only wants to be there for 5 minutes because he wants to get to lunch, or he's trying to get to talk to his girlfriend, or he's going to try to work about something. He's got 1,000 pieces of mail to write on Capitol Hill. It's a little different at the FCC because the experts at the FCC are, and the FTC as well, are very knowledgeable on the subject matter. So you are getting the cream of the crop in terms of a particular subject. They may not have to deal, in my old job, and Patrick alluded to all the different issues at any given time I was dealing with. When I left my last job, I was dealing with half of the US economy and half of the DoD budget and half of everything else going on. So that's pretty substantial. The FCC, they're very narrow in terms of the scope that they may focus on, but very knowledgeable. So if you're going to approach that entity, really know what you're talking about, be able to back it up with examples, and be prepared for the tough questions. And my 3rd piece of advice, and I'll tell you this how many times, never lie. Never misrepresent yourself, never even pretend, you're not sure about the answer, but you're just going to say it anyway for the heck of it. Never do it. Just say, I'll get back to you. You know what, that's a good question. I will get back to you. And then get back to the person. Get them an email and say, here's the follow-up information. Just never misrepresent yourself, because there is no way to rebuild your reputation after you walk out that door and the person finds out the answer and what you said was wrong. There is no way to repair that. And you don't know, you may say, well, it was just one office or just one advisor at the commission. They talk to every single other person in the building. I don't know how many people came to me and would say one thing, and then we talked to another person on, for instance, Senate Commerce Committee. We all talked. We told everybody what everyone was said. So if you were thinking that you could, misrepresent in one instance to another person, it's not going to work. So those are my 3 bits of advice for effective lobbying to extent it can be.
Can I ask one question too? And when you say unlobbyable, you ask tough questions, but you're not a pushover by any stretch.
Well, and yes, I ask tough questions. Yeah. I had the fortunate benefit of my career. People say, how did you pick different bosses? Well, sometimes you pick and sometimes you get, they depends. If you've been fired because you lost an election, well, sometimes you're having to take a job because they actually are going to pay for your livelihood. So you sometimes got funneled in certain directions. But most of the time, I had wonderful bosses. And I look for 2 qualities. You'll all figure out, you're going to work for a million different bosses over your career. Well, millions are probably high, but a couple dozen bosses. And you're going to find qualities that you like in them. 2 qualities I liked and I thought were important. 1, I tended to work for people who were very strong family members and really cared about their family and would rather be with their family than on the morning talk show or on the Sunday talk show. Just was something that was important to me. It helped it helped show me where they cared about the subject matter that they were talking about. They really were in it for the right reasons, in my opinion. And 2, I tended to work for people that were smarter than I was. You could always be the smartest person in the room, and there's a school of thought that's a wonderful opportunity. I wanted to be challenged by people I worked for on Capitol Hill. I wanted them, and if you look at my resume, you'll see some of the smartest members that ever worked in the last 20 years or 30 years, maybe 50 years in the Senate. Those people challenge you. They take more out of you. So when Julia says, I ask tough questions, I have tough questions because I had a boss that, multiple times who, they weren't asking they didn't say, okay, well, here's the follow-up question. They were 4 questions deep. And I had to get that far down before I had to sit back at my desk. And so I had to ask tough questions of anyone coming in so I could be prepared. So they're just my little thoughts. Work for the best people you can. You're going to find, wherever you go in life, you're going to find that there is, you may find that this particular boss is not perfect. But then you're going to go work for someone that actually really is horrible. It is inevitable. Some of you already have worked for me. Some of you, I started my life in a grocery store, moving carts and bottles, and you get, everyone's got a story, right? But you find out good bosses and you find out horrible bosses, and take that experience and those lessons. So someday you're going to be in a boss position. Someday you're going to be in a leadership position. If you aren't already, many of you have been in different times. Take those lessons and apply them then. So I hope that I'm a better person and a better boss and more flexible off the lessons that I learned. Yes.
You speak about this kind of, if it's not broke, don't fix it. We're fixing a problem we created. Kind of looking ahead on the horizon, 2017, 2018, what do you see as issues for consumers that the FCC has a role in helping protect?
Well, my argument is not that we should not do anything. My argument is that we should let the record and the information dictate our activities. So it doesn't mean that in 2017 or 2018, the privacy shouldn't have been an issue. It does mean, though, that I first try and figure out, is a real problem exist that actually leads to consumer harm? I know some people don't like that standard. They want to prognosticate what the market's going to do and what they see things in the future. That happens every day in my business at the commission. Someone figures, they estimate, well, we think the market's going to do X, Y, or Z. They've been wrong so many times, and we don't change those decisions. I can tell you how many things are on the books at the FCC where they made an honest assessment and a guess on where they thought the market was going to be that is still on the books today that made no sense then and makes no sense now. So I try to actually find, I read the record. So some people don't, but I actually read all of the items that come in before me and I read the record. So I'm looking to see what is happening and I'm talking to people. We were in Ohio yesterday and we traveled quite a bit. I was in Buffalo 2 weeks ago and I try to listen what the real problems are, what's happening in the marketplace. And I use that as my basis and as well as the record itself and what materials we find to figure out what we should be taking action on. In fairness, all that good work means absolutely nothing because a minority commissioner has no say in the agenda. It comes from the chairperson. Today we have a very aggressive chairperson. They have an agenda that they walked in the door with, and we're now executing the last couple items of that agenda. We'll have a new chairperson at some point next year. I couldn't tell you when. It's tied to the outcome of next week, which I'm not influencing in one bit, and that will have an impact, a dramatic impact. And I'll say this, by now you're probably done listening to me, but very few people in America, very few people will vote on communication issues. But the outcome of next week will have dramatic impact on the outcome of communication issues and technology issues. As you have changed the association or the organization's name, our worlds are blurring much more substantially. And Neil can attest to all the issues of the FTC and that we now have find are blurry in those that world we live in now. So I say to you, we're going to have in the next 18 months are going to be very exciting time period for without much outcome. We're not going to do a heck of a lot maybe in the next year. That's my guess. I've been wrong before, and don't write it down. But we have to get new people into offices. They're going to have to go through the confirmation process, which I've been through and lived through. So that I suspect that it's going to be a little slow. And that person comes with an agenda. There's probably a 1% chance that I could be that person. And then I'm happy to come back and tell you my new agenda.
I'll leave you with that. I don't give you plenty of time with your good panel. Thank you so very much.
I'll be happy to.
Commissioner.
Of course.
You guys can come up, speakers can come up.
Thank you, Commissioner.
Yeah, exactly. 219 pages.
I just skipped straight to.
It's a quick read.
That's all that matters.
All right. So that was a good way to kick off the discussion. I suspect there's a couple folks on this panel who may have slightly different perspectives than you just heard, but we'll see. Some may agree, we'll have to see. So we've got a great panel, I'm gonna do quick introductions. I'm just gonna go all the way down. So on the far left, Professor Paul Ohm is a professor of law at the Georgetown University Law Center. Specializes in information privacy, computer crime law, intellectual property, and criminal procedure. Professor Ohm served as senior policy advisor to the Federal Trade Commission at the FTC experience, as do a couple others on the panel. And recently he testified before the Senate Commerce Committee on the FCC's broadband privacy ruling. And I'm pretty sure, based on looking at the docket, he's been into the FCC a couple of times to talk about it. And we have Neil Chilson. Neil is attorney advisor to Commissioner Maureen Olhausen at the FTC. His primary areas of policy expertise are privacy, data security, advertising substantiation, FTC deception and unfairness authority, and broadband competition policy. And prior to joining Commissioner Olhausen's office, he was an attorney at Wilkinson, Knauer, my law firm.
He was really good.
Sure was.
He was really good.
Back then it was.
He was my ethics counsel. He was a really good ethics counsel. He's a very good legal advisor.
Next, Julie Kearney. Julie is CUA grad, class of 1998.
98, last century.
She's Vice President of Regulatory Affairs for the Consumer Technology Association, CTA. She represents 2,200 member companies before the FTC, FCC, FDA, and other government agencies. Prior to the CTA, she was at NPR and MCI.
And Haley, Bader, and Potts, Knauer, Schubert, and Bearer. And there's Amy Brown, who was my boss, class of 93. Right? Shot.
Next, we have Claire Gartland, class of 2014. She is EPIC's Consumer Protection Counsel and Director of the EPIC Consumer Privacy Project, Electronic Privacy Information Center, that's what I thought, just making sure. Where she contributes to EPIC's work on addressing emerging consumer privacy issues and safeguarding the civil liberties of consumers and internet users. That sounds good. That's nice. And then finally, to my immediate left is Michelle Rosenthal, who is Senior Corporate Counsel at T-Mobile, where she focuses on privacy, cybersecurity, mobile payments, and other consumer-related issues. She was an attorney at the division of Privacy and Identity Protection at the FTC, and formerly worked in the FTC's Division of Advertising Practices and the Office of Policy Planning. So a lot of FTC experience on the panel. Is anybody at the FCC?
I was an intern, so make sure you get your internship.
So let's kick it off by talking about, and then we can start at the end, make our way down. We don't, just have a dialogue. We're here to have a dialogue. To the extent people have questions in the middle of this dialogue, have at it. Let's try to make this as conversational as possible. So Commissioner O'Reilly laid out his perspective, which was essentially that ISPs aren't unique and don't have sort of comprehensive access to information. He talked about the increasing use of encryption, for example, where more and more data is being encrypted to suggest that ISPs don't really have sort of a gatekeeper function, if you will. He also talked about people accessing the internet using multiple platforms, I think to suggest that there's lots of different ways people get online. So one particular ISP isn't necessarily a consumer's gateway to access the internet. So from a technology perspective, how does this work? is it fair? Some people say that ISPs should be regulated because they have more access. Some say they have less. How does it really work?
So, since I'm one of two people with the microphone, I assume I get half the time. or we'll share, we'll see. So thank you for having me here. This is really wonderful. Before I get into the specific question, I want to focus on one other thing that the commissioner said, and I'll just be very brief about it, and if we want to talk more about it, that'd be great, which is he started from a premise and continually went back to the premise that there is no privacy harm, not only at the ISPs, but I think he was suggesting throughout the entire internet ecosystem. And one way I interpret that claim is that we've got this whole privacy thing licked when it comes to the internet, right? The internet is a privacy nirvana, and we shouldn't worry about anything that's happening with data collections of your behavior and your conduct. Now, if this seems inconsistent with both your understanding of this, and I know there are a lot of students in the room, with the way that you've kind of encountered this, it also doesn't square with my take on this, that the average American consumer is deeply concerned about privacy and would wish that our government entities would do something about it. And the argument I've made, and I know there's lots of disagreement on this panel about this, is that Congress actually did do something about this. In 1996, it enacted a privacy statute that applies to telecommunications providers, and we can talk about how we got it. Okay, so let me get to your question. I'll be really brief.
I disagree.
Yes. Okay. Good. But you know, if we decide there's no privacy online, then we can just pack up and go home, right? If there's no privacy problem online, then we can just pack up and go home. We've solved all of our problems. Okay. Number two. I mean, there's a lot of ways to attack this idea that we live in this encrypted world, and because we live in an encrypted world, our ISPs are rendered blind. So let me just, there are about 15 ways I could have at that, but let me go at a couple of them. One is there was a lot of talk about these things called VPNs. I'm sure a lot of people in the room have used VPNs. They suck, to use a technical term. They're slow, they're not pleasant to use. If you want a decent one, they cost money. And here's the real irony. A lot of them will track you and sell your information to advertisers. So the idea that you can kind of wish your way into appropriate privacy just doesn't sound right to me. The second thing, and I made this point when I testified on the Hill about this, let's say the ISPs are right. Let's say there's so much encryption that they're blind. They can't see anything. Well, guess what? They also can't monetize your information. There's no harm from this rule whatsoever, right? You can't have it both ways. There's no magic wand that lets your ISP make a lot of money advertising based on your preferences, but also blinds them to what you're doing. That's a complete non-starter. And so the people who are forcefully making this argument in the very next breath will make the opposite argument, right? Number one, we can't see a thing our users are doing. Number two, you're taking away all sorts of kind of benefits we can use to lower the price of our service. You can't have it both ways. You're either blind or there's a big impact from this rule. And so that's just this like fundamental disconnect that I've never understood in the argument that's been made. So.
Anyone disagree?
Yes. Well, I think Paul did a really good job of debunking an argument that I don't think Commissioner O'Reilly was making, and it's
I was responding to the question though. Yeah.
It's certainly one that the FTC, when we've considered this issue, and before I get there, when I say we, I should just say me. I'm not representing the views of the FTC, my boss, or anybody else at the commission. But when the FTC has considered this issue, the question isn't the question that we were addressing, and the question that the FCC has been pivoting this new rule on isn't what can ISPs do, but it's are ISPs different? Do they have different access than other entities in the internet? And what the FTC said in 2012 in its privacy report was there are lots of large platforms that are on the internet, and many of them raise concerns. ISPs are one of those platforms. Building on that, I think the 2012 privacy report, for example, mentioned that browsers and operating systems, they can even see your encrypted information because they have to decrypt it in order to present it on your screen. So there's lots of other entities, there's lots of other companies in the internet system that have very, very detailed views about your behavior, and they may seek to monetize that at times. And so what the FTC has said is we need to look and see where there's consumer harm. And on this particular point, are ISPs unique? The FTC said, not really. And since 2012, I think Paul will even agree, there's definitely more encryption than 2012. And in 2012, the FTC looked at search engines, they looked at web browsing, and they said, or they looked at social networks, and they said these platforms are growing. They may not have the pervasive view that the opportunity that some of the other places do, but I think most people at this table would agree that has changed since 2012. Social networking is much more pervasive. Search is much more critical, and it tends to be the place that most consumers start their view online, either social networking or the search engine. And so I think some of the things have changed in a way that make ISPs, while the FTC said they weren't different in 2012, they're probably they may be slightly different, and if they're different, it's in the sense that some of their view has been narrowed. On top of that, another way they're different, although the FTC didn't talk about this, that they are different is they're not using this information yet. I mean, and the question is, why is that a good thing or is that a bad thing? But overall, I think the FTC would say there's nothing that makes them substantively different as far as the comprehensive view of consumers' information.
So Claire, I know you want to get into that. I'm curious from the provider perspective from Michelle and Julie. Go ahead, Claire.
I just wanted to flag also, speaking of the FTC's 2012 privacy framework, they made clear that the framework is supposed to provide a baseline set of privacy principles for entities that are not subject to sector-specific laws. But as Congress indicated in passing the Communications Act and then the Telecommunications Act, common carriers, telecom providers, are intended to be treated differently. And that's the approach that the US has taken in its approach to protecting privacy. We have special laws for financial privacy. We have special laws for health privacy. And similarly, we have special laws for network privacy when it comes to the network provider and what they do with your information. So in a way, it really doesn't matter whether they're different or not at all. The FCC has an obligation here to enact privacy laws following the Open Internet Order, which reclassified ISPs as common carriers. So it's really, we like to say the law is imperative, it's not comparative. The FCC doesn't need to find that ISPs are a bigger threat to act. They need to fulfill their statutory obligation as directed by Congress.
So whether they need to do it and how they do it are two different things. So just from a provider perspective, Julie and Michelle, your thoughts on that?
Well, actually, I'm going to talk as CTA, Consumer Technology Association, is Alex.
It is nice.
Under CTA. We represent edge providers, we represent retailers, we represent home networking, we represent the whole universe of the technology industry. We represent T-Mobile, we represent ISPs, we represent everybody. So I won't opine on whether things should be treated differently, but the issue is once you regulate one part of the internet ecosystem, you are going to have a domino effect on the rest of the ecosystem. And I love all these arcane arguments, are very academic about, what Section 222 of the Communications Act does and doesn't do. My point is that consumers, for the most part, will click through, they don't read, they don't care. Our research shows that, 90% of consumers are perfectly willing to have doctor consults online. People, I think our environment has changed, the Internet of Things is changing how people interact with their data. Sure, it's necessary to have consumer protections, we're working on cybersecurity, but I think a lot of these are great employment opportunities for us. I need about 20 more years of employment, so this is perfect for me. But I think ultimately we're losing sight of the big picture. And I'm happy that we're having these discussions. They're important discussions, but I think we need to look at what the benefits are.
So Michelle, we've got two sort of different threads going now. One is, which Professor Ohm started, which is is there actually a problem that was worthy of addressing at all? And then second is, as an ISP, which T-Mobile is, what is your access compared to anyone else in the ecosystem, and does it justify sort of the FCC's approach?
Yeah, so there are so many things I want to respond to. I get a lot of time, right?
Yeah.
To your questions, and I think to some of the things that raised, there are a couple of points that I think are worth making. First of all, I respectfully disagree with the argument that the FCC has an obligation to act in the way that it acted. I think the FCC, certainly, having broadband privacy rules, we don't even have to get into that, but going past that, the FCC has decided to require opt-in, which is not required by the statute. It is not required under Section 222 under the consent framework. And the FCC specifically chose to go there. And I guess taking a step back, I don't see how this does consumers any good to have two different regimes where the same exact data is being treated differently. Under one regime, it's opt-out. Under another regime, it's opt-in. And to the bottom line here is what's good for consumers. That's what we're all talking about.
For the students in the room,
Yes.
could you just explain what you mean by opt-out?
Yes. So
That
under
would
the
be helpful.
FTC's regime, the use of web browsing information where you go online, high-level app usage information, which apps you're using, that information, if you're using it, if a browser is using it, if an operating system is using it, that information would be opt-out, meaning that the information could be used unless a consumer opts out of the program. Under the FCC's new regime, that information would be opt-in, meaning unless a consumer opts in, a telecom provider cannot use that information. So you now have very, very disparate regimes. And first of all, I think from a consumer standpoint, I think that's really frustrating and confusing for consumers because the consumer thinks that they didn't need to opt in, they didn't opt in over here, but then they didn't opt out over here. I mean, I think it just creates a really confusing system. And as a provider, we're seeing what confuses our customers, what makes sense to them, and that's just not something that makes sense. The other thing that I just want to point out, there was a study recently done by the Progressive Policy Institute that said 83% of consumers care more about this sensitive data being protected, the sensitivity of their data, than who holds it. So again, consumers don't care who is holding their information. They care about the sensitive information. And I think the concern we have here is that, we think it's great that the FCC moved to a sensitivity-based approach, which is the model that the FTC had. But the problem is the sensitivity approach has been kind of expanded and is now including information that a lot of consumers don't consider to be sensitive. Some consumers may, certainly a consumer will care, you may care that they went to WebMD and were looking up, an STD. But a consumer may not care that they were looking at furniture and now got a discount, a great advantage to them on furniture. There are differences, and so the opt-out approach is great because it allows consumers who care to opt out of that model. And I think the concern here is that the opt-in approach is very different. It doesn't allow consumers to kind of get that benefit in the first place and see what it's all about.
Right, and it goes back to trust. I mean, that's really ultimately what it boils down to.
So I'd love to say a quick thing about opt-in versus opt-out. So this opt-out regime that is supposedly so little of a cognitive load on all of the consumers who want privacy, as expressed to the FTC, is really this. Every single entity you deal with on the internet can set its own rules through its privacy policy. And you are obligated as a consumer who cares about your privacy to read every one of those privacy policies, see what they're collecting, and pray that they give you some sort of control that allows you to use the service you want, but at the level of privacy that you desire, right? So that's the opt-out world. And it presupposes this one consumer, and I'd love to meet him or her, who has all the time in the world, can read legalese, right? Doesn't mind clicking 15,000 things. Oh, by the way, the rules can change on you overnight, so you have to be vigilant to keep up with this. Maybe you can install tools to help you fight this. So that's the opt-out world that keeps being held out as this kind of platonic ideal. It's only ideal if you just don't care about your privacy. Then yes, ignorance is bliss, and you can just sit back and let them collect it all. The opt-in world in comparison is really simple, right? This entity, who, by the way, you don't surf to their website very often. Like if you're on the Comcast website, something bad is really happening, right? So your provider, right, will now have one rule, which is if you do nothing, they can't track you. And if you want to do something, if you want to let them track you, they have to convince you that it's a good idea. Right? That's it. It's not a ban. There's no ban on their data collection. They just have to ask you a question and give you the opportunity to answer. Now, I wish that rule applied to the rest of the internet, but it doesn't. But I just have never understood this idea that you're going to be confused by this. I mean, in 2.5 minutes, I just laid out the new rule, and I think it's a pretty simple rule.
So
So I'd actually like to ask, are you all afraid for your privacy? I mean, do you sort of understand when
Maybe
you're
you're not, maybe you're not, and then that's
sensitive
fine.
data or everything? Everything. Right,
so
we're done.
So I read, Paul, your very good brief in defense of the FTC before the Ninth Circuit, and it was very flattering about the FTC's privacy approach.
Everyone
And
loves the FTC.
And so maybe I could just dig in
Sure.
and talk about this. Well, first of all, there's not a hypothetical consumer because that's not the purpose of the FTC's opt-in rule. What we're doing here is setting what Sunstein and Thaler call a choice framework. And the goal of the choice framework is to set the defaults in the right direction.
Right.
So what you want to do is you want to give people who really care about types of privacy that most people don't care about, you want them to be the ones. They're motivated, and they will take the work to figure some of that out. Where consumers have a very universal perception and concern about data, what we've called sensitive data, and I'm a bit worried because that word is also used in the FCC's order, but I don't think it means what they think it means. And so where consumers have a preference that's largely uniform, social security numbers, health information, financial information, those are things that all consumers worry about. So you set the default there to opt in.
And to the extent that web browsing information includes that information, makes perfect sense that would be considered sensitive. I think, that kind of gets to the issue here that if you're including a ton of information that a good chunk of people would not consider to be sensitive, then you're going in the opposite way. And I think I want to make sure we're not talking about privacy in a vacuum here, because I came from the FTC. I care about privacy a lot. It's very important to me. But I also recognize that there are costs and benefits here, right? So many consumers, and I remember when I was at the FTC working on the FTC's privacy approach, which came out in 2012, telling people, oh, this is what I'm working on, and half the people I told were like, I don't care about that. I actually like getting interest-based ads. I like the fact that I went here and then I get an advertisement that gives me a discount. And so there are benefits to some of these programs. And by the way, that's an interest-based advertising. There are also benefits to just first-party marketing. A company being able to say, we know that this person is, for example, looking for new phones. Let's give them a discount on a new phone, right? There are benefits to these kinds of programs, and the concern here is that the FCC's rules go farther than they really need to go to protect consumers' privacy. The FTC approach has been around for years. It's been working. Nobody has been able to show that there's been evidence of harm to consumers, and I think so. Our position is that would be a great approach to apply to the carriers as well.
And you talk about the cost-benefit analysis. I think O'Reilly talked about this, that they failed to do a cost-benefit analysis. At CTA, 80% of our members, we have, the Googles, the front page, the Facebooks, all those, but 80% of our 2,200 members are small businesses. And there's going to be increased cost on them. I spoke at a panel at the Rural Carriers Conference, and everyone just was, they thought, another regulation. I mean, we're supposed to be deregulatory. We're getting more layers of regulation for something that we don't even know how it will work, how will it be enforced. Ultimately, in these rural areas, they spent a lot on infrastructure. Costs are going to go up. They're going to have to hire more lawyers to make sure they're complying with the rules. So, that's great. That's great.
You're speaking to the wrong person.
Exactly, that's true. Forget it. But I do,
Jobs for everyone.
Jobs for everyone. Well, 20 more years for me. But I do think, ultimately costs will go up for consumers as well as they struggle to comply with the new rules.
So play devil's advocate here. Neil, you're what'd you call it? The what choice?
Choice architecture is what I should have said. I think I said choice framework.
So on the flip side, how hard is it to get folks to opt in?
It's hard. Maybe you have some numbers, Michelle, but I shouldn't say it's hard, right? It depends. It depends. When consumers are motivated, they opt in. In fact, the FCC properly recognized, as the FTC has, that there's some ways that you're opting in inherently. So when you subscribe to Comcast, they kind of need to know where your address is in order to give you service. And so there's an implied opt-in there, if you want to call that. There's an implied choice. And so the goal, and I should back up a little bit and just say that the FTC's approach is to maximize consumer choice and effective consumer choice. And that means getting the choice architecture right matters. Because if you draw those lines in the wrong place, you end up having people who make choices that are false choices, more so, and when the average preference is different. And so what happens with opt-ins lots of times is consumers, you have to do it depends on the data, but there's lots of data for which an opt-in is appropriate, sensitive data, and non-sensitive data, you don't want to put that kind of barrier up to a company using it, because the company and the consumer choice has costs. Having to read something, as you properly pointed out, making a choice, even if it's a simple disclosure, it has a cost both to the company and to the consumer. It's a choice of their attention. So if 90% of consumers don't care about this use of data and you make all of them read it, that's a cost of time. It's also a cost of time for the company and compliance. Go to a website in Europe, every single website says, this site uses cookies. Now think about if that's useful. That notice, every single website says
That's
that.
not true. If you're a website that doesn't use cookies, you don't have to say it.
Every single website says this, because every single website uses cookies. And
I
so,
love cookies.
Well, so let me frame the question slightly differently. There's, it's a balancing, right? The government in this case is trying to do a balancing, and we think of it as sort of, we're talking about privacy, we think of it as the government sort of taking steps to protect our privacy, and in theory, right, that's a good thing, right? But at the same time, can the FCC or any government agency do harm on behalf of the hypothetical consumer, for example, but the consumer doesn't even realize they've been harmed because there's opportunities that they're not being given, perhaps?
Right.
Is that a possible, that's the flip side, I guess?
So that's a great question. So I think part of it is, think about from a practical standpoint how this is going to work, right? If you care about your privacy and you're getting ads and it's pretty obvious, right, that you went to usually consumers, we've gotten to a time where consumers really know what's happening. You recognize when you get an ad that seems very similar to a website that you just went to. That stuff happens, people get it. If a consumer has a problem with that, they can opt out. Usually there's an icon on the ad. If there's the ISP, their ISP they have a relationship with, they can go to their ISP website, etc. If a consumer is not getting that, if it's opt-in, they're not seeing it in the first place, so they don't actually know what they're missing out on. And a couple sentences in the text that the provider is going to give to the consumer isn't necessarily going to explain to them, isn't going to give them a true understanding of what they're missing out on. So one example that I like to give is the Uber example, right? A lot of people here, I'm sure, use Uber, and Uber came out with Uber Eats. It's a great program, and this is a first-party program. So this is not like, their information this is just Uber information that Uber has, and they're using that information to advertise a new service that they have. Now, under the FCC rules, there are different breakdowns on what is opt-in, what you can use opt-out, what's inferred consent, which Neil talked about earlier, is kind of just the assumption that you have opted in. But there is a difference between information that relates to a telecom service and information that doesn't. So if T-Mobile wants to branch out and offer a service that's not related to telecom, that wouldn't be bundled with another telecom service, then you can't, you have to provide either opt-in or opt-out depending on what kind of information you're using. Uber, which is under the FTC's regime, is different, right? They were able to take information that they had, analyze information about their user base and what kind of desires they want and where they're going, and decide, okay, this person might be interested in our Uber Eats program. And again, I didn't work at Uber, so I don't know exactly what information they used, but the point that I'm trying to make is that's a valuable program, right? I started getting emails and I was like, oh, this is great. I'm gonna actually use this food delivery service. If I had never opted in the first place, I wouldn't have even known about it unless I just read an article about it online or whatever. So that's from a practical standpoint, I'm just trying to explain that customers really do appreciate these new services.
But I'd love to have the debate about kind of advertising writ large. I mean, this isn't the right forum to do it all the way, but so let's understand what the rule will not prohibit. It won't prohibit advertising. It won't prohibit contextual advertising. So people who use the New York Times website kind of tend to like Uber Eats for whatever reason. In fact, it won't even stop Uber at some level from knowing that you're the type of person who goes to restaurants. Now, if you're a human being, you probably are the type of person who likes to go to restaurants. If Uber were subjected to this kind of rule, number one, you could opt into it. Number two, they can't say, hey, we've seen that you really, really, really like the pizza joint on the corner, and we're going to give you a 10-cent coupon to entice you at this moment to go buy. I'm not sure that the kind of very thin wedge of advertising that we're talking about, not even banning, but just like decreasing a tiny bit, is advertising you're going to miss, right? And frankly, because of the amount of tracking that we're talking about online, a lot of that advertising is still going to be going on. I'll say one more thing about opt-in versus opt-out, right? Because there's a lot of misunderstanding about this. I think, and in fact, this is what keeps me awake, and I think even with this rule, the providers are going to convince a lot of people, maybe people in this room, to opt in. Probably people at this table for sure, but maybe even those of you out there, right? It's not going to be difficult. So I did the narcissistic thing and I searched for my name in the 219-page rule, and they cited me about 14 times, and I'm pleased that one thing they cited me for
It was all those ex-parte.
was calling attention to the work of Lauren Willis, right? This professor at Loyola in Los Angeles, who has documented in really careful detail that banks can convince their customers to take on overdraft protection that essentially amounts to like a 500% APR loan. Like the very people who should not be opting into this have opted in because some California rule and federal rule says we're gonna opt in. So banks, and think about that. Banks, like when's the last time a bank communicated with you in a meaningful way? Here we have Silicon Valley giants, we have telecommunications companies. They're gonna convince a lot of people to opt in.
But interestingly, the Minority and Media Telecom Council was very much against the new rules because they felt that
I mean, I wasn't necessarily even making a minority-majority sort of point, but I think there is that overlay, and I think it's not just race, I think it's also class, I think it's lots of things. I mean, again, so what we're saying is, so Neil was laying out this world where, and he uses Sunstein. Sunstein also is attentive to transaction costs, so we can have the companies bear the burden of making the sales pitch to you and convincing you to opt in, or instead we could just leave every one of you out there as an island buffeted by the winds to deal with this yourself. I think that's a really rational choice to force the companies to do that. And if they convince 98% of us, then in some fundamental way I've lost this battle. But if they only convince 60 or 70% to switch in, I'm glad that we did right by those 30%.
Well, the problem is you're seeing the world as it is and not seeing the potential, the unseen, right? So, and the FTC's approach in trying to maximize consumer choice is, you're right, opt in, well then your argument works for everything.
Sure.
Like opt in everything.
Right.
Anytime, all of you guys, did you opt in to remembering Paul's comments? Did he get your permission for?
I did have to opt in just some video disclaimer by the way when I came into this.
But the question is that argument that basically that argument works for everything. You put the burden on So I don't really buy that. I mean, and the idea that targeted advertising isn't worth very much would be surprising to all the companies that built the internet based on that. And so and I would point out that targeted advertising, you're right.
Works.
If you're doing products that everybody wants, you don't need targeted advertising. You know what you need targeted advertising for? Those people who are very narrow segments. Those people that
So I hesitate
hard
to
to reach
say,
otherwise.
I hesitate to
So
say
those
this
products,
at a school named Catholic, but I do work for a Jesuit university. So, for example, through geofencing technology, one entrepreneur has said, I will sell ads that will only be seen by women who have gone into a Planned Parenthood facility recently. And a lot of people are buying those ads. And I'm not sure what those ads say, but again, this is micro-segmenting you.
But that's
based
an
on
example
your
of something that would be sensitive.
Is it
and
though? Wait, is it
nobody's-
really that you walk through a particular address?
Precise geolocation
Yes,
certainly.
precise.
So this is why the
Yes.
whole notion of sensitivity varies by every individual. Like what's sensitive to you is not going to be what's sensitive to the person sitting next to you.
So
But what
let's
industry has said,
what if
what
we
industry has said is, I love this. This is fun. But what industry has said is we should have a self-regulatory group of people who get together and decide what's sensitive or not for you. Right? This is what some of the things I've said. Right? So they're probably gonna look a lot like the people on this panel, and we're probably gonna sit around the room saying, drugs, well, we can't say all drugs are sensitive. Just the ones that have to do with the bedroom or something, right?
This is what the FTC does. So I will say, remember, we're setting a default.
Okay.
We're not making the decision for everybody.
Right.
That is very different. If we were trying to make the decision for everybody in the country or everybody on the internet, that would be really hard, right? But all we're trying to do is set the default and let people move off that default if they feel motivated.
And the only point I'm trying to make is
questions in the audience.
And Michelle has to make a point. Michelle?
Go ahead, and then let me have some questions.
No, but nobody here disagrees that there is information that is sensitive, and I think we all feel comfortable with an opt-in approach for that information. I don't want to speak for everyone, but I think everybody, that's the FTC approach, that's all the industry has said that, nobody questions that. But to Neil's point, just because there may be one person that would go a step beyond, I mean, what you're trying to do is regulate for the majority of the people. That's what makes regulation work, and that's how good government works. So when you go beyond that and you start including information that some people might find to be sensitive, but many people might not, then you're taking away an opportunity for people that they don't necessarily know is there. So I just want to be clear that walking into an abortion clinic, I've heard that example a ton of times. That would be sensitive. I don't think there's anybody here in this room that would question whether that's sensitive. So,
What about visiting a Planned Parenthood website? So if that's as you would want history to be non-sensitive,
right? And I agree with you that would be sensitive. But the thing that I want to make clear is, companies stay as far away from this stuff as you could possibly imagine, okay? I'm not saying there may be some company out there that's an advertising company that's trying to, get somebody to agree to show their ads for, that are abortion related or what have you, Planned Parenthood related. What I'm saying is companies, the industry, stays away from that. And I remember having these conversations with companies when I was working at the FTC, because we raised the same hypotheticals with companies. Like, well, what do you do if somebody, looks at this website or someone looks at this website? Companies stay very far from that. There are industry self-regulation, there is guidance, and anyone who belongs to these self-regulatory groups don't go anywhere near these kinds of sensitive health topics.
And we have our own guiding principles that Alex Reynolds worked on for health and wellness data, and our companies unanimously agreed. It was like the easiest hard project we did.
I really want to hear the question.
Yeah.
Okay, so Drew? Yeah.
Thank you, Patrick, and thank you all for being here. Just a two-part question, if I could, and I'd like to go back to one of the premises of the whole discussion about harm. Commissioner O'Reilly talked about how he didn't find any harm, and some of you have agreed that there's no harm. If you could elaborate as to what kind of harm would there have to be for you to really believe that there needs to be a regulation, and if you can talk a little bit more about harm, and if you believe that there is harm, if you can talk about what kind of actual tangible harm are we seeing in the marketplace. And if I could, and I don't mean to throw the discussion and conflate it with other countries, but I know in the European model, the rules are a little bit different, and given that we have a duopoly of rules with the opt-in, opt-out, what do you think would be the step forward? Would it be a congressional, perhaps, law or a different agency to harmonize these rules for the betterment of really what we believe is our privacy?
And are you a student here? Or no?
Class of 2013, right after Alex.
Okay.
So I'm going to go first with harm. So, we just did one, right? So this example, this story we can tell. I mean, part of the problem is you could have this discussion on anecdotes or you could have it on statistics. And either way, I think you're going to get a lot of examples of concrete harm. So if you'll excuse me, let me just do a few more anecdotes. So right there is the time that Office Max or Office Depot, sorry, I'm libeling one of those two companies, revealed that their database had an entry for a shopper that said daughter killed in car crash, right? There is the report from the FTC that showed that a lot of these big data providers will categorize you into urban strivers or single parents, right? So there's this idea that every one of us, rather than kind of bonding together in a society with people who are kind of like us but not exactly like us, You're being hyper sliced and defined into just who you are, including the one proclivity that's going to make you spend a few extra pennies on whatever consumer good they're trying to sell you, right? And then we can move from the individual to the societal. There's a lot of good scholarship about the kind of cumulative effect of the chilling effects of always thinking you're being watched. And so there was a 2014 study. Now, this wasn't ISP surveillance. This was what Edward Snowden taught us about the NSA, but where they interviewed something like 200 or 300 novelists. And the novelists said, in my daily life, I refrain from doing searches I want to do. I don't call people that I want to call. I don't send emails I want to send, right? So here are the people who are defining our culture in many ways, and they're not engaging with this wonderful, like the greatest information resource ever created, the internet, in the way they want to. And you have to ask every one of yourselves, like, is there a Google search you've refrained from doing? Is there an email you haven't sent? Particularly since Jim Comey started talking about this stuff, right? But if that's true, what is the cumulative effect of these chilling effects touching every one of us in these small ways? So I could go on and on, but these are the kind of stories we worry about when we worry about the harm of internet surveillance.
Right, and at the FTC, we look at stories, and a lot of stories, and we look at our statute, and we look at not just what are the cumulative injuries, but what are the cumulative benefits. So the cumulative benefits of information sharing are enormous. The internet, the reason the internet is great is because we're all sharing information on it. And part of the reason that your Google search is good and useful is because they can fund it. If you're right, if you took that away, if in some magical world you could eliminate paying for Google and still provide that service, that would be terrific, but that's very hard to reach. And to get more specific to your question about what is harm, the FTC doesn't just do privacy and data security. We have a very broad jurisdiction over fraudulent behavior, but our privacy and data security come under our Section 5 authority largely, and we have very specific
Section 5 authority.
Section 5 authority of unfairness and deception. So we pursue practices that are unfair and deceptive. And under unfairness, the types of harm that we look at are largely there's substantive harms. They're typically fiscal. There are health and safety risks. There is a small injury to a large number of people, could be a substantial harm, but there's some other factors in unfairness. And emotional harms typically don't reach that threshold. And so unless they're sizable enough that they cause they could cause a fiscal or some other injury. So in the privacy space, a lot of those examples, even those stories, they sound really scary, right? Like that Office Max had somebody down as daughter's daughter died. That's probably public record information. I mean, that's probably out there somewhere. The question is, how did that harm that consumer? Now, that's embarrassing. And if somebody used it in the wrong way,
I think it's beyond embarrassing.
Well, it depends on how they used it, right?
I think it's subjective.
But it is subjective, and it's an edge case, and it's not.
No,
really...
just to be clear, we have the facts right. A mailer appeared at his house. The first line was his name. The second line said daughter killed in car crash.
Right.
This was within like a year or two.
So the question is,
that wasn't just embarrassment. That was something deeper,
okay.
I'm guessing.
But how would you? The question is, how do you address that?
Yeah.
How do you address that under the law?
Fair point.
Very
Right.
difficult, right? That was a mistake. Believe me, Office Max did not want to do that.
No.
Right.
Office Max gets no benefit from delivering an advertisement based on whether your child is killed in a car crash.
It's comeuppance, I mean.
Right. And so this advantage of sharing information, and I think Commissioner O'Reilly made a great point on it. Like, there's a big difference between novelists afraid that the government is going to throw them in jail and people sharing information because somebody wants to sell something to them. Those are really different categories. It's why the Constitution focuses on, it's not the only reason, but it's one reason that the Constitution focuses on limiting government collection of information. Commercial information, there's lots of other mechanisms. Most of these companies want to sell you something, and you don't sell something to somebody by making them angry or embarrassed or scaring them or making them feel like you're being creepy. And so
that's another question.
So is there any possibility that the FTC moves to the same direction that
Great
the
question.
FCC and start adopting more stricter regulations? And that the other question is during the open meeting, Commissioner Moscow talked about the possibility of to form an interagency privacy council. So I was curious to know your opinion about that.
Patrick, did you forward her your
I was just gonna say.
I swear, we're so prepared for that.
Did you spot it?
Did
Did you opt in?
No, I did not. So two separate questions. One, what do you think will happen? Will the FTC move in some direction? And maybe Neil, you shouldn't answer this. I don't know, or you can't have at it. Will they move towards the FCC's more strict approach as to what is sensitive information, and or should they? And then secondly, this concept that Commissioner Rosenthal had laid out.
Well, I can't say what the FTC will do. I can say what I'm certain my boss would not support a move in that direction. And I think, in the quick skimming of the couple paragraphs, the order came out while we were in here, of the discussion of sensitive information, I can't imagine FTC staff buying that argument. It divorces sensitivity from choice almost. And so, again, to get back to it, the reason we focus on the sensitivity of information is because that's the information that consumers care about, and they have an incentive to overcome an opt-in barrier if they want to share that information. By broadening that definition of sensitive information and disconnecting it from what consumers care about, I can't figure out a way that the FTC could get there. So
to be clear, I worked at the FTC for a year, and there has been a very interesting tactical move that many in industry have made when it comes to comparing the FTC to what the FCC was considering. So they always talk about the FTC's approach, but whenever you hear that, you have to understand that they are mischaracterizing the FTC's approach. So what they're pointing to is primarily a 2012 privacy report, which on its very first page disclaims that this is a guide to how they enforce the rule, and said it was a very thoughtful deep dive into kind of how we should think about privacy. And in particular, this idea that the FTC says sensitivity requires opt-in, non-sensitive information. That doesn't exist. That's not an FTC rule. There's never been a statement that says, if you gather sensitive information without an opt-in, we'll call it unfair or deceptive. I would love that rule if that got proposed, but that's not the rule, right? And so then you layer on top of this the fact that it's a small agency that can only enforce so many privacy cases a year. What you really get, that's a fair point, but what you really get is you really get almost entirely a deregulated state. And Neil's right, I just did spend a week of my life, and I'll never get back, telling the Ninth Circuit how important the FTC is when it comes to privacy enforcement. That's despite the fact that they have all these challenges that I just laid out. And so industry like to say, hey, level playing field, let's do a sensitivity opt-in rule. That's not the FTC's rule. And so what they really mean when they say level playing field is, number one, create a rule the FTC doesn't have. We'll pretend it's a level playing field, but to me that's, or number two, what we really pine for is the relatively deregulated state where only the worst of the worst actors get any attention, much less punishment from the FTC.
Where consumers are.
Well, and I think too, a lot of it will play out in the courts. I mean, there will definitely be an appeal. And I think this is not over. Yes.
Well, we have another FTC or former FTC.
And I can more freely speculate than Neil can. But, so I just want to, Neil and Paul just touched on kind of two separate issues, right? The issue of whether the FTC would do it, and the issue of whether the FTC can do it. And so I agree with Paul that under Section 5, with no rulemaking authority, the FTC isn't, all they can do is offer additional guidance like they have in their previous report. And for them to truly have parity with the FCC's just released rules, there would need to be legislation, I think. I don't know if you yeah, okay. But whether the FTC would do it, I think is a completely separate issue. And I agree with Neil, again, can't speak for the FTC, but just based on my experience there and knowing how people think and analyze issues and think about harm, and the FTC is based on Section 5 of the FTC Act, which is a harm-based approach. They're used to thinking about harm, and they do cost-benefit analysis. It's a little bit of a different way of thinking, and I just don't see the FTC coming forward and recommending this. I also want to say, there's been a lot of talk about, the FTC's report was 2012 and it's been 4 years, and so much, everything changes in a minute in technology, and so lots has changed. I would remind everybody, or tell you if you don't know, that the FTC filed comments in this proceeding and made it very clear that the positions that they previously took, they stand by. So they weren't changing their opinion on anything. They again talked about the sensitivity approach. They talked about concerns relating to content and the 5 categories, but they did not talk about, the fact that web browsing or app usage data generally is sensitive. And so I think it's pretty safe to say that the FTC's approach has not changed, even though they haven't put out a report and we don't know that for a fact. I think based on their comments, we can see that they have the same opinion.
And I thought Edith Ramirez was very measured in her, I thought, screaming on the inside. Yeah.
And if I could just touch a little bit on the idea of the fact that the FTC doesn't have a rule. If you've taken torts, there doesn't have to be a rule for there to be law. And there is law in this space, and the FTC has brought a lot of cases to enforce the privacy and to protect the privacy of consumers. So it's a different approach. The FCC tends to pass large industry-wide rulemakings that make a lot of news because they have a lot of fighting, right? Because everybody is worried and trying to get their piece of the regulatory rule right. And the FTC brings cases. And when we find consumer harm, we bring a case against somebody and settle that case or bring it in court. And that's just a different process. It doesn't mean there's not a rule. It doesn't mean it doesn't mean there's not law. And in fact, the FTC does enforce several rules. COPPA is one of them. And strangely, COPPA actually, the FCC's new rule now more or less applies, the Children's Online Privacy Protection Act, by treating web browsing and app usage as sensitive information. That kind of looks like what Congress said we should do for children. So in some sense, the FCC's rule now applies the rule that Congress said was appropriate for children's information to everybody on the internet.
Let me just add one thing, because I want to make sure that I didn't go to. I agree with everything that Neil said, and I think the FTC's guidance isn't just a piece of paper. I mean, it talks about how the FTC would bring Section 5, how they interpret Section 5 of the FTC Act, what they think is unfair, what they think might be a deceptive practice. So, the guidance, any guidance that the FTC issues is, kind of showing industry and showing the world, or showing the country, this is how the FTC kind of thinks about their authority. So,
but just so for my admin law students in the class, the reason that the FTC doesn't promulgate rules is because they don't have notice and comment rulemaking authority. Right?
Yeah,
Whereas the FCC does. Right.
We have it under Magnuson-Moss, which is a very, very, very laborious procedure. And so unless Congress provides specific authority.
Formal rulemaking power, but not informal notice and comment rulemaking.
So question, Lee, and
maybe one last
last
question,
one.
and then I think we can continue this engagement.
Over beer.
Yes.
So, we talked a lot about opt-in, opt-out. The FCC rule also dealt with take it or leave it provision. And, assuming that you're given a choice, to either opt in or not, it would seem as though the FCC rule would prohibit someone who's not opting in from, still being able to use the service. So can you talk about the interplay between the FCC and the FTC and take it or leave it provision?
So the FTC's report also has the same kind of thing. The idea being that, you can't just say, yeah, we're getting opt-in. If you use our service, you've opted in. And if you don't use our service, then you haven't opted in, right?
I can disagree with that a little bit because the report is, maybe I don't think this is a disagreement. The report says that in certain areas that might really matter. There are lots of places. There are lots of places where by choosing, like I said, the implied consent is you by choosing to employ the service that you are opting in to sharing the information.
Right,
So-
if it's consistent with consumer expectations,
Right.
right? So, right, the idea being, if you're using, you know, if you're using the Yelp or a service that's based on like what are the nearest restaurants nearest to me, it's pretty obvious that you're using your location. Your location is going to be used in order to provide that service.
But to the extent that the services evolve over time, to include, let's say, location-based, and you had started using the service when location-based surveillance wasn't used, and then suddenly it becomes, and suddenly it pops up. It would seem to me that you opted in at a point when it didn't make a difference, but now all of a sudden you should.
That would be, I think that would be that's a question of whether is it a retroactive change, is it a material change, that it's treated a little bit differently.
I mean, the only thing I'd add is it invites a discussion about choice, right? And so part of the problem why take it or leave it might be even worse in this setting is most people in America really have, especially when we're talking about fixed broadband, right? One choice, two choices. And
I look forward to the competitive analysis and the FCC rule.
Right, I'm sure it'll be rich, right? We can agree on that.
There won't be much.
But the bottom line is, so that's what worries, I think, consumer advocates more about take it or leave it in this space. Even now, I don't want to be naive. Like it's hard to leave Facebook, and it's hard to leave Google in some sense. So they're not unique again in this place. And going way back to Neil's first comment, there's a lot about the ISPs that aren't unique. The one thing that is unique is that Congress wrote a privacy law about them, right? And so that's the only argument we're making. But so take it or leave it. Maybe we worry more if your only two choices are DSL. Does DSL still exist?
Yes.
Comcast, right? And maybe FiOS if you've been blessed from above.
Probably didn't exist in '96.
Yeah.
Congress wrote this rule.
It actually did. But so that's.
So I think we need to wrap it up. We're probably already past time. I've got a lot more fun questions here, but so I encourage everybody to go to the FCC's website because it'll be on their homepage. If you don't want to read the whole thing, they have a fact sheet, which is their perspective of what it says.
Or if you're willing to pay, I think his firm will rate you.
They'll rate you.
Absolutely, prorated.
Well, I think I'll subsidize it, right? From subsidies, yeah, should we talk about this?
The one thing we didn't get to, and it's an interesting subject, is the Ninth Circuit's decision recently, which a couple of folks at this table participated in amicus filings there, which basically says that, and Commissioner O'Reilly disagreed with it, which basically says that if you have any sort of activity at all as a company that is a quote common carrier activity, the FTC has no authority to regulate you. So you can imagine that's a fundamentally new concept as opposed to activity-based versus status-based, which is a very interesting conversation, which I'm sure all of them would like to talk to you about over beer. So let's wrap up with thank our panelists, please.
I just wanted to say thank you very much. I hope everyone will join us for a reception in the atrium, and thank you to Patrick.
And real quickly, could all of our current students stand up so that the people that aren't students can figure out who they should talk to during the
You're outnumbered. Oh, no,
Thank
Thank
you.
you.
That's good. I'm glad you did that. Phil Weiser.
No, it's really nice to meet you. It's really nice to argue with you.
I can do this all day.
I know, you're good at it. You were a computer scientist too.
I was. And in fact, I still do more of that than I do law.
I may have to go.
Like I'm teaching law students how to program.
Oh, that's so cool.
So Paul, I saw that article in the New York Times.
That was such a funny article. That was. No. Trust me, we're not being shy about the idea. Of course, we want to spread it. Yeah. So, hey. Yeah. If you want to bring it to another law school in town, we would share it.
That's awesome. Yeah. Oh yeah. Sure. Question.
Good job.
See if I can grab this hard.
Yeah.
I'm excited the hunk,
the black.
Yeah, it's always
Nice to meet you.
I know, I'm here sort of supporting my body.
Hi.
Thank you.
Good.
How's the day?
It's great.
Yeah.
I didn't want to.
Oh my goodness.
Our lives are
You're
taking our
great.
place.
I
I was trying to
cannot-
coordinate. You take the notice.
Yeah,
you take
yeah,
the choice.
well, I know, and I'm just like,
Liz, you're another glass of wine, you know,
Oh, that's so
Yeah, like,
sweet.
help
Thank
you.
you. Thank you. Hi, Alex, how are you? Nice, I can always use it. Yeah.
I like to use it.
I know, I'm like, I don't even want to open my email because I feel like it's gonna be.
Yeah.
Yeah, she
Oh, wow.
said
Yeah,
the
no,
one.
and the washing post somehow.
People kind of lose
It's
their
really complimentary.
Okay, so let me go to that. It's like,
Yeah.
okay, a million
Yeah,
emails,
like-
yeah,
It was
a bunch of tables. Okay,
saying,
and
no,
so
it's
I don't
not
have to get a
only
ticket separately or register.
And so, sorry about that.
Yes,
And then
no,
in
no,
the
it's.
We kind of had planned to like, okay, we know we're gonna have to separate this.
Right.
There's some people on
Exactly,
staff who just
yeah.
calmly
Right, right,
go
right,
through
right,
the
right.
process.
Yeah, so sorry, I'm like.
Yeah, no, you're good, you're good.
Yeah, okay, actually, it's, I think it'd be great and a fun way for you to.
We've been so like up in arms in the past
I know.
like, month or something that there's no.
We have this whole plan of like everyone in the business, and like having meetings, and like within a week, we'll get you this, within a day, whatever. And we were supposed to send it out like, we were like, oh, we'll send it out by the end of the day. And
Oh
then
my god.
Link up.
Pretty.
crazy.
I want to encourage you all to come out.
Yeah, absolutely.
Yeah, sure, I can come for a little bit. Yeah, check out Georgetown, I'll deny all.
Girls?
Hey.
Yeah, get
Alex, we
I don't know.
gotta go mingle.
People keep mentioning me, I'm like, no.
No,
I'm just here.
we just, you know, we protect our own. Are you sticking around?
Just for a few minutes.
Yeah, I'm like.
We were, divvying up the responsibility of summarizing Freedom Magazine.
Is it really?
Oh my god, because it just literally came out.
Yep.
Wow, it's so good to see you. Oh my gosh, such a pleasure. It's great to be here. You are still here, right? Still here. So is Alex in here?